Hello, I'm Bill Bullard with R-CALF USA, the voice of the independent cattle producer in the United States of America. Well, regulatory overreach occurs when an agency like the U.S. Department of Agriculture, or USDA, attempts to do more than it is authorized to do. In October of 2019, we alleged in a lawsuit we filed against the USDA that it had unlawfully engaged in regulatory overreach by attempting to force U.S. cattle producers to use radio frequency identification ear tags, or RFID ear tags, if they wish to ship their cattle across state lines. Specifically, we allege USDA had no authority to issue such a mandate unless it first initiated a public notice and comment period, which is the procedure Congress requires all federal agencies to follow before they can change the statutory or regulatory scheme impacting U.S. citizens. But USDA attempted to circumvent this important procedure and instead acted as if it had the authority to not only regulate, but also to legislate. Of course, as soon as we filed our lawsuit, USDA knew it had no authority to legislate, meaning to impose new requirements on America's cattle producers without first following the law that it was obligated to follow. So USDA found itself in a bit of a pickle. Rather than face the prospect of court sanctions for its unlawful act, the USDA voluntarily withdrew its RFID mandate in its entirety, thus correcting its regulatory overreach. That is, at least with respect to its attempt to unlawfully mandate RFID. On September 11, 2020, we filed another lawsuit accusing the USDA of regulatory overreach, this time with respect to USDA's operation of its 35-year-old beef checkoff program. This new lawsuit builds on our pending lawsuit that is now under appeal at the Ninth Circuit Court of Appeals. In our pending lawsuit, we allege that USDA had been violating the constitutional rights of independent cattle producers for decades by forcing them to pay for the private speech of a private state beef council without their consent. When the magistrate judge issued its findings and recommendations that supported our allegation of a First Amendment violation to the Constitution, the USDA began taking steps to try and correct its violation. It began entering memorandums of understandings, or MOUs, with the private state beef councils, requiring them to grant the USDA authority to pre-approve every word of the State Beef Council speech. The USDA claims this corrects the violation because no longer were cattle producers forced to subsidize private speech. Now, with the MOUs in place, the government insists that the speech of all the private state beef councils is now government speech, because the councils must now express the government's message, not that of private entities. Well, the USDA is doing here almost exactly what it did in our RFID case. It is attempting to change the statutory and regulatory scheme that the private state beef councils have been operating under for the past 35 years. And they're doing this simply by telling the councils that they must now grant USDA authority over all of their speech, if they wish to speak at all. Now, we believe this too is unlawful. We don't believe the USDA had any authority to affect the rights of the state beef councils with their MOUs without first following the congressionally required public notice and comment period. And that's the heart of our lawsuit. We now allege the USDA is again engaged in unlawful regulatory overreach by bypassing its legal obligation when making changes to how it regulates American citizens. And the USDA may find itself in a pickle again. So in our pending lawsuit before the Ninth Circuit, we allege a long-standing violation of the constitutional rights of independent cattle producers, and we're seeking a request from the court to declare the transfer of beef checkoff money to fund private third-party speech unconstitutional. And we want the court to enjoin that from occurring. But in our lawsuit, which we just filed in Washington, D.C., we allege a violation of the Administrative Procedure Act, which requires the public notice and comment period that we've discussed. And we're asking the court to declare that the MOUs that USDA entered into with the state beef councils are unlawful. Now, there's a lesson here. When a federal agency like the USDA engages in regulatory overreach, what it is really doing is eroding the rights and liberties and privileges of every American. Left unchecked, this could cause serious harm to an entire industry, like America's live cattle industry, and it could force participants to exit the industry. That's why industry groups like R-CALF USA are so important. we vigorously defend, preserve, and protect the rights and liberties of our independent cattle producer members to ensure that their economic success is not compromised by a federal agency with the propensity to try and do more than it is authorized to do. We hope you'll support R-CALF USA and invite you to go to our website at www.r-calfusa.com. With that, have a productive week.